Now, it was a moment of almost delicious defiance, a demonstration of considerable courage by Senator Natasha Akpoti-Uduaghan, a woman challenged and some would say provoked into a test of her boldness, and she didn't disappoint. Flanked by the prominent political activist Aisha Yesufu and a number of her other supporters, Senator Uduaghan must have known that it was going to end the way it did, with her locked out of the National Assembly by security agents. But after vowing to resume legislative duties following a court ruling that the Senate should consider recalling her, she had made her point, and in the full glare of the world's media. As she herself suggested, history will remember that on this day, a brave woman dared to do what in her heart she knew was right. But after that impressive show of bravado, what happens next? Has she merely cast herself into deeper waters against what should be one of this country's most revered institutions, though it's looking more like one of the more reviled, as one critic put it, a Senate that would not hesitate to hit back with a sledgehammer, even as it insists that there is no subsisting court order mandating it to recall the senator before the expiration of her suspension.
The Senate, under the leadership of Counsel have decided to become lawbreakers, and by denying me entrance into the chambers to resume my duty. It is very important I do mention, and Nigerians should know, that even though we do have 2 federal government criminal cases against me, they are on criminal defamation, simply because I spoke up on the threat to life. And everybody has a right to speak up on their threat to life. And Nigerians should know that I am not facing charges of corruption, I'm not facing charges of embezzlement, I'm not facing charges of drug abuse, and neither am I facing charges of murder. And it's ironic that the people who are actually testifying as witnesses in the 2 federal government cases have cases at EFCC, have files at EFCC on record that they have actually embezzled state funds running into billions. So far, I've not been given any official reason. I've only read on the papers yesterday that I should not resume today because the Senate has appealed. And that is why I presented to you that the Senate has not appealed the judgment. It is Akpabio himself. He is abusing power by willing the entire institutions to fight me. It's a personal vendetta that Akpabio is unleashing on me by hiding under the whims of the institutions, and it is wrong. It is totally wrong.
Senator Natasha Akpoti-Uduaghan. Well, for more on this, I'm joined now in the studio by Ibrahim Wali, one of the lawyers who represents Senator Uduaghan. Thank you very much indeed for coming in.
Thank you for having me, Charles.
Just briefly summarize for us what happened at that National Assembly today and what Senator Natasha Akpoti-Uduaghan was aiming to achieve.
Well, summarily, she was only aiming to achieve the attainment and the enforcement of the court order that was delivered, the court judgment that was delivered by the Federal High Court. But what we saw today at the Senate is a continuous contempt of the judiciary generally. You know, if I take you back to the history of this case, you'd find that this is just the newest episode in terms of the contempt by the Senate of the judiciary itself. So when this suit was filed, and by the way, it's very important to contextualize, you know, the nature of this suit. When this suit was filed, it was filed actually before the suspension itself. It was filed in anticipation of the potential suspension. In fact, it was filed after the, entire debacle that, saw the purported, referral to the ethics committee. So we went to court and we told the court that, okay, there's a potential breach of our fundamental rights. In fact, a real and potential breach of, the fundamental rights of the applicant. And the court gave us an interim order to say, okay, everybody, all parties, the Senate, the clerk of the Senate, the ethics committee, and the Senate president himself should maintain a status quo and come to court in just 10 days, in fact. And then we served them that court order. So that was the first court order in the matter. We served them the court order within 24, 48 hours. We, put forth our affidavit of service. They also acknowledged service, but they went on the next day to sit down in defiance of the court order to, purportedly look at her, the petition against her, and then they now made a report, to the main floor, which now, suspended her, quote unquote. So after the suspension, we now went to court immediately. We filed a motion for interlocutory injunction to void the suspension itself. So there are two processes now before the court. The original process, that borders on a right to fair hearing and, everything that happened on the, I think in February, late February, and then there's this that has to do with the suspension itself, which is in fact in contempt of the order of the existing order of court. But the first court that handled the matter ended up recusing himself and sending the file back to the CJ, who then transferred the matter to the new court. So if you read the judgment of the court itself held that all the previous applications, which we don't exactly agree with, all the previous applications before this court are not going to be looked at. We're only going to look at three processes: the originating summons itself, the interlocutory application that has to do with the suspension itself, and the preliminary objections of the respondents, that is the Senate President, they filed preliminary objections. But if you look at the first part of the order, the court now gave, the order of contempt against the senator, even though the contempt application itself is outside of the three applications the court claimed it was going to look at. I
mean, for the lay person on the streets,
yes,
although you're putting it out very well. I mean, it sounds complicated. I mean, just to narrow it down to the real, very kind of minute focus, which is the court judgment that was delivered by Justice Nyako.
Yes.
Was that judge's ruling on her recall advisory, or was it a binding order mandating the Senate to recall her?
It is absolutely the latter. It is a binding order. We shouldn't even be, putting forth these arguments. First of all, when you look at the order, the preamble begins that it is hereby ordered as follows. Right, that is what it begins with, and then the court goes on to give its orders. So the court said that regarding her suspension, especially the duration of her suspension, it is in conflict with the Constitution, especially Section 63 of the Constitution, which requires that the yearly senatorial seating or maybe National Assembly entirely should be 181 days, and then the suspension was 6 months, which is 182, 183 days. So she held that this is excessive, and this is not in line with the Constitution. That holding in itself, without any consequential active order, it suffices, because any action, this is basic law, any action that is found in conflict with the Constitution is automatically void ab initio. That is, it is as if it never happened at all. And then the court now went on, to say that the Senate have the power, and indeed they should. That was the word of the court. Indeed, they should recall the senator. If you look
I'm going to. I don't mean to interrupt you. I'm going to come to the language of the court, which is what is quite confusing, to be fair, at the moment. But what about the penalties that the court imposed on her, such as the payment of a fine and an apology? Has she obeyed that court order? Is she intending to obey that court order?
Well, first of all, we have to understand the nature of the court order itself. Now, there's what is known as Sheriff and Civil Processes Act, which regulates the mode and manner in which you can bring someone into contempt of of a court order, or of a court ruling, or of the court generally, right? The fact that the court has penalized her with a fine simply means that the court has found her criminally liable for contempt, because a fine is a criminal offense. You get to pay a fine. Now, in the SCPA, before you can even kickstart the process of, to kickstart and oversee and complete the process of finding someone in contempt, you ought to, serve them with an order 48, notice of disobedience of court order, give them the opportunity to come to court and to try to explain and to purge themselves. And this was never done, So, and in fact, we were surprised to see that the court made rulings on these contempt proceedings. So there's a notice of appeal, obviously. We've gone on appeal to challenge parts of the
Right.
decision. And the first part of the decision we're challenging is, this, what is it called, this so-called fine that the court gave. Yes, we do not agree.
But you're also challenging, you're planning to go to the appeals court for clarity of that federal high court judgment.
No, we're not going to the appeal court for clarity of the federal high court judgment. We are clear as to what the judgment contemplates and purpose.
But it's not being, I mean, the Senate is disputing it.
Exactly, but
with its lawyers as well.
Yes, but if you look at the Senate itself has not filed a notice of appeal. They have not appealed the judgment as it is. The Senate President have filed a cross appeal, but even if you look at his cross appeal, he's only challenging it on 2 grounds. The first ground being, the court decided that the preliminary objection succeeded in part, which is a bit absurd, respectfully. And then they are the ones now seeking for an interpretation, seeking for the court to, make exactly. But we're not seeking
to clarify
for any interpretation. Our own appeal is saying, this contempt proceedings, this 5 million naira, there was no due process, there was no fair hearing. And then on the other part, that the preliminary objection ought to have failed completely. All of the preliminary objections ought to have failed. You cannot on one hand say that, the Senate or the National Assembly has, the internal democracy to decide on their mechanisms, and then on the other hand, and you say that, but where there is a breach or an anticipation of breach of fundamental human right, then you are going to lift the veil of this internal democracy.
But just for clarity, yes. Did the judge find that Senator Akpoti's fundamental rights were violated by the National Assembly?
Absolutely, because the court found that the suspension was excessive. Said it was excessive. It was not in line with Section 63 of the Constitution.
but in that context, I mean, would it be fair to say that what the judge issued were observations that imply but do not specifically order that the Senate should comply with those observations?
Not at all. The Constitution is clear, especially Section 318, that judgments include orders, commands, and even recommendations. And then, like I said, you don't find this in the argument part of the where the court goes into the obiter dictum of its decision. You find this in the order section, the order portion of the judgment. The other portion is the binding, enforceable portion of the judgment. When a judge has to advise or recommend, a judge does it in the analysis and evaluation of the issues itself. You can see that, okay, this is the law, this is the position, but in my opinion, it ought to be A, B, C, D, E, F, G, H. But then when it comes to the decision itself, when it comes to the orders, you have to, there's no two ways around it. Okay, we had our understanding of the issues. The respondents had an understanding of the issues. It would make no sense for the court to now give us an opinion. Like it doesn't make any sense. We have an opinion, they have an opinion. The court is the arbiter. The court is supposed to adjudicate and give us the final position, and that is what the court has done regarding that particular issue. That it was excessive, it's not in line with the law. The court could have and should have gone further to strike out those sections of the act and the Senate rules that she thought was excessive.
But I mean, would it help if there is some form of greater clarity in these judgments from the courts?
Without a doubt. If I speaking, from the legalistic
because all this could easily have been sorted if it had been ineluctably clear
I agree
that
with you.
This is what we mean.
I agree with you. The court's judgment fell short of the basic tenets of a judgment. It does, clarity. In fact, the evaluation itself, it's 33 pages, but the first 25, 26 pages is just the regurgitation of the processes filed. The judgment itself is just 7-8 pages long, and if that includes the portion of the order. So yes, I have to concede without a doubt that it could have been and it should have been a lot clearer, and I'm confident that the Court of Appeal are going to do the right thing regarding
right. So what would you like to see come out of all of this beyond obviously having your client reinstated? Would you like to see the National Assembly, for example, push ahead with key reforms? I mean, if so, what might those be? Because the whole point of this is that it's not just Senator Uduaghan, it's about the whole system and how it treats people and how it from her point of view, violates the rights of people. So what would you like to see come out of it?
I'm very glad that you asked this particular question, because the reality is, you know, the issues around this case is way bigger than the parties themselves, right? It has to do with our collective existence, our you know, the rule of law, you know, the enforcement of law, and you know, the inequality in Nigeria. It just shows, it portrays, because the Senate has consistently disobeyed court orders, for example. So if the court's, you know, potency is challenged in this manner, then obviously you know, it shows that we do not have a judiciary, or at least an fully effective and independent judiciary. But obviously we are not you know, unaware of the fact that, you know, the rule of law regime in Nigeria currently is almost absent. You know, this is, and if this can happen to a senator, imagine what can happen to you and I. And indeed, it happens to you and I every other day. You know, and in fact, this is a case, you know, an interested case, you know, of national importance. But really, it mirrors what actually happens, you know, in many other cases. And this confusion, you know, in terms of the clarity of the judgment is not novel to this case. And almost all the judgments that our courts respectfully churn out these days.
But it's been highlighted by this case.
Yes, you can use this and extrapolate to the, you know, greater, you know, institutional issues. But the Senate, you know, I mean, they have an array of senior lawyers, senior advocates. The Senate President himself is a lawyer, head of the Ethics Committee, a lawyer, and Senator Monguno himself, a lawyer. I know these are parties involved in the case. They could have said, or they should have said to themselves that, okay, whatever the case, you know, like, let her resume my duties. I mean, people actually voted out. And okay, if they decide to appeal, for example, it's going to be on taxpayers' money. It's going to be on our money. If the Senate already, you know, prosecuting this case was our money, and if they continue, you know, it's our money, and then it impedes the rule of law, and then it just, it's sad all over.
You do make some very reasonable points there, and I thank you for coming in.
It's my pleasure.
Do let us know when there are sort of more developments on this case. Ibrahim Wali is one of the lawyers who represents Senator Uduaghan. Thank you very much indeed.
It's my pleasure.